The Kentucky Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Kentucky. What is a rental agreement? A rental agreement, or a lease, is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, the landlord should also disclose the names and business addresses of the people who own and are authorized to manage the rental unit. In addition, the landlord should provide the prospective tenant with a written explanation of utility rates, charges, and services before the rental agreement is signed, unless the utility charges are paid by the tenant directly to the utility company. One more action required from the landlord in Kentucky is to inventory the premises jointly with the tenant within 5 days upon delivery of possession. A written record of any furnishings or appliances provided should also be completed by the landlord, and a signed copy should be given to the tenant. What is also specific for Kentucky leases is that prior to entering into a rental agreement, the landlord should inform the tenant of the location and number of the separate account with the security deposit. The landlord should also present to the prospective tenant the listing with the possible damage to the unit, which would be a basis for a charge against the security deposit and an estimated repairing cost. The tenant should sign such a listing, or if they don't agree to it entirely, create a statement of dissent. Security deposits. According to the Kentucky Code, establishing the maximum security deposit is completely up to the landlord. The landlord should return the security deposit within 30 days after the termination of the tenancy. If the tenant leaves not paying their last month's rent, the landlord has 60 days to return the deposit. The landlord can use the deposit to repair any property damages caused by the tenant using the damage listing signed by the tenant at the termination of the occupancy. Landlord access. According to the Kentucky Revised Statutes, the landlord should give a 2-day notice before entering the apartment to inspect it, do necessary repairs, etc., and do it only at reasonable hours. Entering without a notice is allowed only in case of an emergency or according to a court order. Termination of agreement. To terminate a month-to-month tenancy, at least 30-day written notice should be sent by either of the parties. For a week-to-week tenancy, at least a 7-day notice is needed to terminate it. Notice periods for non-payment and non-compliance. If the tenant fails to pay rent, the landlord should give them no less than 7 days after receipt of the notice to either pay or vacate the premises. If the tenant violates other terms of the lease, the landlord should give them no less than 15 days after receipt of the written notice to remedy the violation or vacate the premises.